Hi, my name is Sherry Hale, and I'm at U.S. Law Shield's headquarters in Houston, Texas. Today, I'm interviewing Doug Richards, who is an independent firearms program attorney in Colorado. He used to be a federal prosecutor and has over 100 jury trials under his belt. He also co-authored U.S. Law Shield's book, Colorado Gun Law, Armed and Educated. Doug, thank you for joining us today.
Hi, thank you. I'm very happy to be here, very honored to be here actually. Always happy to talk to people about gun rights and Second Amendment and how they can make their communities safer.
Doug, you have defended many gun owners. How did this become important to you?
For me as a lawyer, I feel it's important to support and protect and fight for every single part of the Constitution, all of the amendments. And one of those is the Second Amendment. It's in second place for a reason. I mean, our first most important amendment is freedom of speech, and the Second Amendment is right to bear arms. And I don't take that lightly. So I will stand up and defend anyone's right to bear arms, to possess and maintain firearms.
Who can own a firearm in Colorado?
To answer the question of who can own a firearm in Colorado, it's a lot easier to tell you who cannot own a gun in Colorado. You cannot own a gun in Colorado if you're currently on probation and the court tells you you can't have a gun. If you're the subject of a protection order, whether it's a civil or a part of a criminal case, you can't have a gun or a rifle or any sort of firearm if you are a convicted felon or if you have a conviction for domestic violence. And sort of looping back to where we were at the beginning of this answer was with probation, even if you have a deferred sentence and you're on a deferred sentence for domestic violence, you should consider yourself a convicted of that offense while you're on the period of supervision. So anyone else can lawfully possess a firearm in Colorado. We actually also are unique in that we have an open carry statute where we are allowed to, you're allowed to carry open anywhere in the state except in Denver County. What that means is just what it sounds. You can have a gun on your hip, but it has to be exposed. You can't have it concealed. So sometimes I get questions from U.S. Law Shield members about, well, you know, I don't have a concealed handgun license, but I have an inside the belt holster, so you can see the butt of my weapon or whatever it might be. You know, isn't that technically open carry? And the answer is no, a big no with an exclamation point. Open carry is just that. It has to be open. It cannot be concealed in any way, in any manner.
What is the age requirement to own a handgun in Colorado?
To own a firearm in Colorado, you have to be at least 21 years of age to purchase a handgun, at least 18 years of age to purchase a rifle. If you're underage, you cannot possess a handgun. It's actually a crime to do it. There's certain exceptions. So, and when I say a handgun, you can't possess a firearm or a handgun if you're under 18, unless you are part of a hunting program, unless you're part of you're going to the shooting range, unless you're on private property where your parents are or your guardians are, and they've given you permission to do it. And otherwise, it is a crime, it's a misdemeanor for you to do that. For an adult to allow a minor to have possession or have access to a firearm, it can also be a felony in certain circumstances. So it's very important that if you are in a household where there are firearms accessible to minors, it's extremely important that you keep those firearms locked up in a gun safe where they cannot be accessed by minors, because, I mean, you don't just have criminal liability, but there's also civil liability should a minor get a hold of a weapon or an invited guest that's a minor at your house gets a hold of the weapon. You could really find yourself in a heap of trouble.
Who can obtain a CCW in Colorado?
In Colorado, a concealed handgun license or a CCW can be obtained by anyone who's not a prohibited person, and anyone who's not a felon or someone who's the subject of a protection order. Colorado is what's called a shall issue state. So the sheriff in each individual county is who you petition to for the ability to carry a handgun or a firearm concealed. They will do a background check on you. In some counties have a reputation for being a little bit more stringent than other counties. Some of the more rural counties have a reputation for giving the concealed handgun license without having to jump through as many hoops as, for example, Denver County. I have a concealed handgun license. It's issued by the Denver Sheriff. I didn't find it to be unduly burdensome to go through the background check, but the sheriff also has the ability to deny your request for concealed handgun license even if you don't have a criminal conviction. And that could happen if they find that you have maybe an arrest prior that for maybe a drug or alcohol matter that was dismissed, or a prior arrest for something involving a violent offense. And the sheriff, even though you don't have a conviction in the criminal courts, the sheriffs can take a look at your record, pull police reports, and say, well, I get that you're technically allowed to have this license, but I'm going to not deny it for this reason. You can then appeal that decision, and we can actually appeal that to a district court ultimately and get a judge to sign off and say that the sheriff abused their discretion in exercising their right to deny or grant your right to a CCW. But it's a difficult hearing to win because the sheriffs don't just, in my experience, deny people their licenses just willy-nilly. Typically when somebody comes to me and they say, well, my CCW application's been denied, and we start going through it, undoubtedly there's something in their history where maybe there was a commitment for a mental health issue or something along those lines that I have to have a sit down with the client and say, listen, this is why. We can start getting you into some treatment and eventually get a doctor to write a letter, and we can reapply and take it up to a district court at that point. But in my experience, as long as you're not a person that falls in a category that we've been talking about, you will be able to get a license in Colorado.
Let's talk about automobile carry and transport. What does the law say about carrying a firearm in your car? Is it legal to carry a gun in your car without a CCW?
Yeah, and I hear this a lot where people say, oh, well, my car is an extension of the house. And there's no law that says that. But what the law says is that you can have a gun in your car, and you can even have it concealed in your car, as long as you're having it there for lawful protection while you're traveling. And that's what the statute says, and there's no real restriction on or definition on what that traveling means. I've litigated that before. The law is really supportive of people who want to carry a firearm in their car, whether it's concealed or whether it's not concealed. If you have a rifle or a shotgun or something like that in your car, it has to be unloaded. You can't have any sort of anything chambered at all. But if you are carrying a pistol or a handgun in your car, it can be loaded. The only restrictions are related to going onto school property. If you have a CCW, you can have your firearm in your car locked up on school property. If you don't have a CCW, you cannot do that. You can't have your pistol in your car if you go onto property, the post office. But if you are stopped by a law enforcement officer, there's also no requirement that you tell the police officer that you have a pistol in your car or that you're armed. I think and I advise that my clients always tell the police that for your safety and for mine, I'm armed, I have either my CCW or I don't have a CCW. My firearm is sitting in my glove box, and all the paperwork I need for this traffic stop is in my wallet. I will never go into that glove box. So I always recommend that people do that. But as long as you are in Colorado, you can have a firearm in your car without being in violation of the law.
So let's say I've been pulled over for an alleged traffic violation, such as speeding, and I have a gun in the car. Can the police seize my gun? And if so, when does it have to be returned?
So, to answer your question, yes, the police can disarm you on a traffic stop, and that's totally discretionary with the officer. If you feel that that's being done for some reason that you just got off on the wrong foot with the police officer and you guys got sideways with each other, I always recommend just say, you know what, officer, I would appreciate it if you would contact your supervisor and have your supervisor come to the scene with us and participate in this traffic stop. Typically that doesn't happen, and quite frankly, typically the police do not disarm you. The only time that I've found that clients are disarmed is if the client is perhaps being investigated for something along with that traffic stop, such as a DUI or a drug offense. Or, for example, I had a client recently who was stopped on the side of the road for a traffic. During the stop, the police officer learned that the person was perhaps a prohibited person, where they were not allowed to have a firearm because they may have had a domestic violence conviction. And the client actually got into an argument with the police officer on the scene and called me during this argument, and I said, listen, you're never going to win this argument on the scene. It's very important that if the officer wants to take your firearm from you and they believe that you're a prohibited person, let them take your firearm and let me handle this after the stop. Because the only thing you're going to do is earn yourself an invitation to jail. And so the client did that. We were able to sort everything out later on down the road. It was a snafu with some paperwork and some computers and some government employees. And when you put all those things together, not everything gets done when it needs to get done. And that's what happened in this case. So to answer your question, yes, the police can disarm you at the end of the traffic stop. If they've disarmed you and it's really just for their own safety during the traffic stop, then they must give you your firearm back at the end of the traffic stop. And I could see that maybe happening if you are traveling on a remote part of our highway or county road in the middle of the night, and if the police officer just wants to disarm you for their own safety, that is something that they can do. It's their discretion, and you should let them do that if they feel that they need to do it. But just know that at the end of the stop, you will get your firearm back.
So on to the question that is on everyone's mind. When is it legal to pull the trigger?
What people should be asking themselves is, when can I stop a threat? Not when can I shoot, when can I pull the trigger, but when can I stop a threat? Because that's really what it is. When somebody is putting you in a position that's requiring you to use any form of self-defense, any amount of self-defense, whether it's just using your hands or all the way up to using deadly force, the real question that's in your mind should be, can I stop this threat using a lesser degree of force? Because later on, there's going to be a set of jurors that's going to be determining whether you acted reasonably or not. And did you act reasonably in approaching the situation? Did you act reasonably in determining that a lesser degree of force was inadequate? Were you in reasonable fear for your life when you decided to pull your deadly weapon out? Were you in reasonable fear for your life and you had no other reasonable course of action when you decided to stop the threat by firing your handgun? What that really does when you think of it in terms of stopping a threat, it really indoctrinates you into thinking in terms of, I'm the victim and this person's putting me in the position of having to defend myself to stop the threat. Because when you start saying things such as, when can I shoot the other person, it sounds a lot different to prosecutors and to members of law enforcement and to jurors than when you say, I needed to stop a threat. Now, I never want my clients to make a statement to anybody ever, but if you happen to make a statement, it needs to be something like that, where you're saying, I needed to stop a threat, because that's what you are doing. You are stopping a threat. So if you were in reasonable fear for your life and you had no reasonable other alternative other than to use deadly force to stop the threat, then you can do that.
Can you use deadly force when protecting your property in Colorado?
In Colorado, you cannot use deadly force to protect your property. I remember when I was a prosecutor in Texas, and there was an old saying that no horse needs stealing, but some men need killing, right? And so the idea is that you can use deadly force to protect property, and you cannot do that in Colorado. it's a good thing to know and to think about, because as we go from state to state with our firearms, either traveling with the gun in the car or carrying concealed with a reciprocity statute, it's important to know how one state's laws might differ from another state. And in Colorado, it's very, very, very important to remember you cannot use deadly force to protect property. You can use deadly force to protect your life or someone else's life. And if someone is coming after you to steal your property, such as there's a robbery or there's an intruder in your house, and they're stealing your property and you feel like your life or someone else's life is in danger at the same time, then there are ways that you can use deadly force to protect yourself. But you cannot just use deadly force to protect property. And a great example would be if you were in your house, it's the middle of the night, and you hear the car alarm going off, and you look out and there's some punk kid trying to steal your radio, and you stick your firearm through the window and pull the trigger, you will be going to jail that night, whether you hit the person or not. You will go to jail. There is no lawful protection of property using deadly force. So just don't do it.
Can I merely display my firearm in order to stop a threat?
You can, but you have to realize that when you do that, reasonable minds might differ on whether or not your actions were reasonable or whether the other person was actually constituting a threat. The displaying of the firearm can be done in a few different ways. One, it can be done by just, for example, maybe you've got a pistol under your jacket and you're in some situation, you undo the jacket and let the person see your firearm, right? You haven't pointed it at them, but you've certainly suggested to them through your body language and through, I'm sure, a few choice words that might be having been exchanged during that scene, that you might intend to use the firearm. Another way might be for you to actually pull the gun out and either hold it to your side or actually point it at a person. And in that way, you start crossing the lines from what, if somebody disagrees with your assessment, from what might be considered disorderly conduct, displaying a weapon, which is a municipal violation, all the way up to felony menacing, which is a felony. So I have found, it's been my experience, that there's no real delineation between one act and another and the type of charge. And what I'm getting at is, it seems like it's completely made up on the scene as to what you might be charged with if the officer doesn't believe or a prosecutor doesn't believe that you are in reasonable fear for your life based on this other person's conduct. I've had situations where I've had multiple clients do essentially the exact same thing in response to the exact same type of threat. And some of them end up having no charges at all. Some of them end up in a municipal court, and some of them end up in a district court fighting a felony charge, all with, quite frankly, the very same type of conduct, the same situation. They have the same kind of background. And I haven't figured out the bright line rule where one act of defending yourself could land you in this type of hot water versus that type of hot water. So that's why when I talk to people at seminars, why having Law Shield, U.S. Law Shield, is so important, because you never know when this situation is going to come to you. You're not seeking it out, it's coming to you. And when you are in a situation where somebody is putting you in fear for your life or someone else's life, and you feel that you have no other choice but to use deadly force, then you need to make sure that you have either a ton of money to hire an attorney to defend you, or you have U.S. Law Shield there to back you up, because there is no real rhyme or reason on how law enforcement is handling these cases. And I'm seeing more and more and more of them as more and more Coloradans are arming themselves, and more and more DA's offices and sheriff's offices and police departments are trying to figure out who's right and who's wrong in a particular situation.
Doug, can you help us understand the Castle Doctrine?
Well, let me I think to understand the Castle Doctrine, I want to put it in perspective to other affirmative defenses, because the Castle Doctrine is its own unique doctrine. It's a pretrial motion that provides you immunity. So just if you can imagine that for a minute and go back to everything we've been talking about self-defense, using deadly force in self-defense of yourself or another person. That's what's called an affirmative defense that's used at trial. And if you've ever been part of a trial as a juror or, God forbid, a defendant, at the very end of the case, the judge will read a set of instructions to the jury, and that's the instructions on what the law is. And if the defense has raised self-defense as part of their defense, the judge will read to them the law on self-defense, and the judge will say, okay, well, for example, in Colorado, I'll read it to you, and it says, if it's an affirmative defense to the crime of, for example, murder, if the defendant used deadly physical force in order to defend himself or a third person from what he reasonably believed to be the use or imminent use of unlawful physical force by another person, he used a degree of force which he reasonably believed to be necessary for that purpose, he reasonably believed a lesser degree of force was inadequate, and he had reasonable grounds to believe and did believe that he or another person was in imminent danger of being killed or receiving great bodily injury or serious bodily injury. Those are affirmative defenses that a jury would consider in determining whether or not you were guilty or not guilty of a certain conduct. And with an affirmative defense, you say, yeah, I did it, but I have an excuse. Yeah, I did shoot this person, and I either hurt them or I maybe, God forbid, killed this person, but I had a good reason, and that's the affirmative defense. This is all presented at trial, okay? Before trial, you will be going to court many times, many times. And for one of those appearances, it will be for what's called a motions hearing. And a motions hearing is an opportunity for your attorney to litigate maybe statements that you made, maybe litigate the way that the police collected evidence, maybe litigate certain discovery issues. And one of the main things that you could litigate in a case like this, in a shooting case, is the Castle Doctrine. And that's where the Castle Doctrine is brought up. It's a pretrial motion. And with the Castle Doctrine, it only works in a very select few circumstances. And it has to be in a dwelling, okay? So if somebody comes into your house and they commit a crime in addition to the trespass or in addition to the unlawful entry, and you believe that they're going to use an amount of force, no matter how slight, against yourself or another occupant of the dwelling, then you can use deadly force to stop that threat, okay? And what that does is it provides immunity to the charge on criminal and civil. So what that means then is, if you are charged criminally, your attorney would file a motion to dismiss based upon the Castle Doctrine. The attorney would raise it'd be an evidentiary hearing, so there'd be witnesses testifying. Your attorney would raise the issues that I just mentioned about how there was an unlawful entry, there was a crime committed in addition to that you thought reasonably that this person was going to use an amount of force, no matter how slight, against any occupant of the home, and that's why you acted the way you did. If the judge agrees with that, the judge will dismiss the case. There will not be a trial. That's the end of it. And you have immunity from any civil liability that, for example, maybe the estate of the person that you may have killed in trying to stop the threat, they might be sort of, watching from a distance. And if the judge grants the immunity motion or the Castle Doctrine motion, then they cannot sue you for your actions. That's why the Castle Doctrine is it's a very unique statute. Not many states have anything quite like it. And it's an incredible thing that we as Coloradans have to know that we can protect ourselves in our homes without fear of criminal or civil liability.
I've heard there are immunity statutes that protect gun owners who shoot a criminal. Do they also prevent the gun owner from being sued?
Well, there's an immunity statute that we've been talking about, which is the Castle Doctrine. And that's really the only time that you can be, that you really have safety from lawsuit. There's a statute in Colorado that lets a citizen make a citizen's arrest. And I will tell anyone that will listen to me, never do this. never make a citizen's arrest. It's the worst thing that you can do because you don't know what the situation is, you don't know what's happening, and you can really find yourself sideways with the law. So some folks might believe that they have immunity from prosecution by, or from civil liability by asserting this ability to make a citizen's arrest. I tell you, do not do it. Just stay away from it. It's a very difficult field to navigate. And so really the only place that a Coloradan should feel safe in having immunity from criminal or civil liability is with the Castle Doctrine.
Does this statute prevent me from getting sued?
So many people, they'll come into my office and say, well, I acted in self-defense. Well, you know, and I'm presumed innocent. And while those two things may be true, a prosecutor might be disagreeing with that. And you still have to go and present this defense either to the prosecutor until they understand your point and they agree to dismiss the case, or to a jury if it needs to go that far and let the jury know exactly what happened. It's the same thing with the civil case. You could, you can beat the case, but you still have to go along for the ride. And so it doesn't take much more than a little bit of time to go down to the courthouse and file a lawsuit against somebody and have them sued and serve civilly. So you could be right. You could be totally right in everything you did, and you still have to defend yourself. And that's why having a lot of money in your back pocket to pay for an attorney on a criminal case or a civil case, or having U.S. Law Shield is so critical, because these things cost money and there's no way around it. And it's not that, a lawyer just wants to get paid for doing nothing. It takes a lot of work to defend these cases. We need to deploy investigators. We need to do very close and careful forensic review of all of the evidence. It takes a lot of time to sit down and prepare for each of your court appearances. It takes a lot of time to go back and forth. It takes a lot of time to sit down and draft very creative, original motions that will be attacking the case that the prosecutor's bringing against you. And all of that happens whether you were right or whether you were wrong. So it's critical that you, if you're going to carry and be the armed citizen, it's important, just as important as carrying bullets in your gun, to being prepared with a legal defense and having an attorney that can do that for you. So I can tell you I've had two cases very recently that were a Coloradan just defending themselves from a very obvious threat. And it's a threat that's obvious to everyone except one person, that's a prosecutor. And in both cases, we got all the way to trial before the prosecutor finally figured out the case and agreed to dismiss it. And in both of those situations, each client ended up paying in excess of $50,000. Neither one of them had coverage such as U.S. Law Shield, so they had to either borrow money from friends, take money out of their retirement. They have to do. You've got to do what you've got to do to find to make your legal defense. And guess what? At the end of this, where the DA provides a dismissal and thinks that they're saving the day, and they give us a dismissal, my client's sitting there thinking, okay, well, what am I supposed to do? How do I get that money back? And the answer is you don't. You don't get that money back. It's very difficult to find an attorney that specializes in these types of cases. It takes a lot of time to do that, and in this profession, time is money. And it costs a lot of money to prepare the right defense. Now, you can go out and you can find an attorney on the street in Colorado that'll take, couple $100 to defend you on a case like this. And if they do, you should run. You need to find an attorney that really knows what they're doing. You need to find an attorney that's been in the trenches, that litigates these cases, that goes to trial, and that the prosecutors know will go to trial. And only those kind of attorneys are the ones that U.S. Law Shield associates with, and that's who you should be associating with.
Gun owners are typically very responsible, law-abiding individuals. So why do we see these good people end up in jail?
I've found that there's really four main reasons why a good armed citizen will end up in jail after they've had to defend themselves from another person's attack. One of the main reasons is the other person tells their story, and it's a lie about how you attacked them first. And this brings up a great reason why I tell people not to carry open, right? Don't carry, even though you can carry open, don't do it, because you could be walking down the street and minding your own business, and somebody goes up to the police and says, hey, that guy over there in the red shirt, which you're wearing a red shirt, that guy with the red shirt and the pistol on his hip just pointed a gun at me. And now you're stuck trying to defend this and saying, I didn't do it, and how are you going to defend yourself from doing something, from having done something you didn't do? So, when you are in a situation like this, you're at the mercy of what everyone else said, and so it's very common for the person who came after you and who was the subject and recipient of your deadly force to then try to pretend that they were the victim in the case, and it's not uncommon for them to lie to the police or to lie in court. So that happens all the time. So that's a big reason. Another reason is that when the police show up at the scene of any sort of call, they are already in their minds putting together their theory of the case. And when they present a case to a prosecutor, that prosecutor is also putting together in their mind the theory of the case. I mean, I know this because I was a prosecutor for a long time, and I did this with every case where you sit there and you're reading the report, and whether you have a statement from the suspect or not, you are in your mind trying to say, okay, why did he do this? Or why did she do that? Or why did they act this way or go into that room or draw that weapon? And you're putting together the theory of the case. And it's a lot like putting together a jigsaw puzzle and just smashing the pieces together to make them fit. And that's what happens a lot of times when police and prosecutors get together and put together their theory of the case, is they can get it wrong. And it's like, imagine a spaceship in orbit or a plane in the air, and if they're off trajectory, if their trajectory is off by a little bit, at the very end they're off by miles and miles and miles. And that's what happens in these kinds of cases. Another way that good people end up in bad situations is by have a police officer or a prosecutor being predisposed to thinking that citizens should not be armed. Whether it's for political reasons or whatever, they have decided that the Second Amendment is not really, it's really an amendment in parentheses. And we shouldn't be allowed to carry firearms, we shouldn't be allowed to defend ourselves. And so whenever, and I've had this a lot of times happen where there's a question about, is this person the one that's going to go to jail, or that person's the one that's going to go to jail? Whoever's got the gun is the one that's going to go to jail. And a lot of times that's the police mentality. And when you get to court, the prosecutor says, well, he had the gun. And I say, well, you know, it was our position that we diffused the situation. And the prosecutor says, no, your client wanted to win the fight. And that's why they pulled the gun. So a lot of this can be trying to get over those either political or for whatever reason, this dogma that they've already just sort of been ingrained with, indoctrinated with through either their career or their upbringing or whatever, but they, for whatever reason, don't like guns, don't like citizens that have guns, and they're going to take it out on you. The biggest reason, and as far as I'm concerned, the number one reason why a good person goes to jail for defending themselves is they think they can fix it by talking to the police. They think that when they're there at the scene, they can just calmly talk to a police officer and explain it as reasonable people do. But what you don't know is that the police officer is, like we talked about earlier, coming up with their theory of the case. And they may have decided right when they walked on the scene that they don't like you for whatever reason, right or wrong, and that you're going to jail, and they're going to try to get all of the information out of you and use that against you. And perhaps your statement is recorded, either with a iPhone or recording device or on video, but you know, even worse, maybe it's not. And you're telling the police officer all these things, and the police officer is then tasked with going back to their desk, hopefully later that night, but sometimes not for days or weeks later, and they've got to recall what it is you said to them in that one moment. Do you think that they're going to remember all of the exculpatory things, all the things that help you, or do you think that they're going to remember all of the stuff that puts a nail in your coffin and helps advance their own theory of the case? And that's a rhetorical question, because you know the answer to that is that they're going to remember it the way that they want to. Now, I'm not saying that police do this because they're bad people. They're just like you and me. They've got a tough job to do, and sometimes they meet good people and sometimes they meet bad people. And it's their job to try to figure out what happened and present a case to the prosecutor, and they'll decide this is the story and that's the story that's presented to the DA. And so you can really end up in a bad spot by opening your mouth on at the scene and trying to fix it on your own, because this is not a situation you can fix. As soon as you bring a weapon into an argument, you have put yourself into the court process. You just have to assume that. You have to assume the police are going to show up. You have to assume that they're going to disarm you. You should plan on going to jail, okay? This is just the way, this is the world we live in right now. And so the thing you need to know is the only thing you can do for yourself is hurt yourself by trying to explain what you did or why you did it.
If you are forced to use a firearm, what should you do immediately after bang?
If you're put in a situation where you have to defend yourself or another person because of an attack from a third party, the very first thing you should do is call 911. And when you call 911, you should announce who you are, tell them your name, tell them your location, tell them what you're wearing, and you tell them that you are the victim of a crime. And you tell them to send police, and you tell them to send an ambulance, okay? Now, let's break that down, and let's talk about why we do that, because that's all you're going to say. You're going to hang up the phone at that point and say nothing else to anyone else, okay? Now, you call 911 for obvious reasons. You want to get the authorities out there because someone may have been shot, but you also want to make sure that the police come out there and intervene, because this was a very difficult situation for you and for everybody else. And you could, I would tell you that 9 times out of 10, the police are probably already being called. When you talk to the police, you want to identify yourself and tell them who you are. Tell them your name. Tell them what you're wearing, because when you're talking to the 911 operator, the 911 operator is sending these text messages of sorts to the mobile data terminals, these MDT computers inside of the police patrol cars. And the police are on their way and they're looking down at their patrol car, the computer, and they're getting a readout of, okay, the person, the reporting party is wearing a brown suit with a blue tie and a white shirt, and they are 40 years old, and this is their name, and that's who they're going to be looking for when they get to the scene. When you tell them that you're the victim of a crime, now you start getting, you start planting the seeds for when the police and the DA are trying to decide their theory of the case, like we've talked about. And the 911 operator will hopefully write that into their call notes. So-and-so person, victim of the crime, or victim is wearing X. And if you can get that in the call notes, when the police come to talk to you at the scene, it's going to be a lot different situation than if they think that you're this crazy lunatic with a gun. All right. Now, when the police do arrive, you want to make sure that you are not armed, and you should put your firearm on the ground, unload it, put your hands up in the air, let the police know where it is. Do not hide your gun. Don't hide it. You could be charged with tampering with evidence, and I've seen that happen before if you try to hide it, or in one of the cases that I've done, the client says, well, I was just trying to make it safe and put it in a place where nobody would find it, and the DA and the police, and coming up with their theory of the case, decided that that was tampering with evidence. So don't do that. Now, you've told the police what your name is. You told them what you're wearing. You told them you're the victim of a crime. You told them to you told the 911 operator to send police and send an ambulance. Now, why do you send an ambulance? Obviously, if somebody's shot and hurt, you want them to get some treatment, right? But the real reason you want the ambulance is for you. Because what's going to happen is the police are going to come and try to take a statement from you right there at that moment, okay? And something you should know is this. If a police officer is involved in a shooting, okay, here's what happens for them. They have an officer that gets assigned to them, okay? And that officer stays glued to them for the rest of that shift. And they go back to the police station, they sit down in a quiet room, they have a Coke, they have a donut, they have something to eat, they relax. They're not there at the scene, no one's asking them any questions, and that officer that gets assigned to them isn't there to ask questions. In fact, it's the opposite. That officer's there just to kind of get them through this traumatic event, okay? Then they go home. They, the police officer involved in the shooting, they go home and they have 2 sleep cycles. 2, not 1, 2 sleep cycles. And then they come back with an attorney and they decide at that point what statement they want to provide after having consulted with an attorney and getting their head around the situation, okay? Guess how much time you get to decide if you want to have an attorney? You know, none. Guess how many people get assigned to you that take you to a quiet room to give you a Coke and a bite to eat? Nobody. They are trying to plug you for information right there, right then. And so by asking for an ambulance, what you can do is get some interference and you get a trained EMT to start looking at you. And what you do is you tell the EMT, you look them in the eye and you say, I realize that you're qualified to look me over here, but I want to be taken to a hospital. I want to be seen by a doctor. I want to be hooked up to some machines. I've just had a very traumatic event. My heart, I don't know what's going on in my heart, but you need to have all of those things checked out immediately. And they will put you in the ambulance and take you to the hospital. And hopefully during that time, you will calm down, the adrenaline levels will come down a little bit, your heart rate will come down a little bit, you will be seen by a doctor, and that's important, you need to do that. But hopefully during this time you can reach into your wallet and get your US Law Shield business card out and call US Law Shield and get me dispatched to you immediately, because that's what you need. You need the exact same treatment that the police get, and that they're not going to give you unless you ask for it and unless you demand it. And so what you need to do is tell the police, I'm not talking to you. I've just had a very traumatic event. I'm the victim of a crime, and I need to be taken to the hospital. So let's recap. You've had a situation. Call 911. You ask for police, you ask for an ambulance, you tell them you're the victim of a crime, you tell them what you're wearing, and then you hang up the phone. Now, let's talk about why you hang up the phone, because I'm going to tell you this. In that situation, the 911 operator is going to try to keep you on the line. And that line's being recorded. And I've had plenty of situations as a prosecutor and as a defense attorney where what happens in that gap between when you're done telling them you need help and when the police show up, that can take, a few seconds to a few minutes, can be critical to the case. I've had situations where people are laughing in the background of the 911 call, and maybe it's just nervous laughter because you've just been through this traumatic event. But guess who doesn't think it's too funny? The cop and the prosecutor that's looking at you to try to file a charge. So that's why, and that's just one example, but that's why you hang up the phone immediately. Don't answer it when they try to call you back. You sit there, you wait calmly for the police to show up and help you.
In your opinion, how important is that 24-hour hotline service that US Law Shield provides?
The 24/7 hotline that US Law Shield provides is incredible. My clients can call me 24/7, but I'm not awake 24/7. US Law Shield has somebody available 24/7 that can dispatch me to the scene and make sure that I get all of the relevant facts. So you call US Law Shield, they will take all the important information from you and contact me and get me to you wherever you are to make sure that I can help you. I can tell you this also. I sit in my office with my clients all the time, and before they hire me, maybe they're shopping around to a bunch of different attorneys, and I hope they do, because that's what I would do if I was facing some serious charges. And they undoubtedly come back and they hire us. And once they do that, there's this tremendous sense of relief. I mean, every single time I see them just let out this huge sort of sigh, and their shoulders, which were really tense before, they're finally relaxed, because up until that moment, they've been doing all of this by themselves. They had to bond out of jail by themselves. They had to go to court maybe once or twice or 3 times by themselves. They had to answer questions from their family members and do all of this on their own, without any help from someone who does this every single day, like me. And so now they've got me with them. I've got their back. I'm in their corner. and they can see that we've got the resources in our firm to really attack this case. And I always feel so bad when I see that, and I don't talk to them that much about it, but I see it, I recognize it, and I feel bad for them because I get what they've been going through. And when I have a member coming to me from that's a U.S. Law Shield member that is in the same situation, they thankfully haven't had to go through that. They haven't had to worry about, well, where am I going to find my lawyer, or how do I even find them? Do I Google it? Do I ask for a recommendation? Do I open up the yellow pages because I think they still exist somewhere? I mean, how do you even find an attorney? And then you've got to go make appointments and find them and talk to them. And even at that point, how do you know that you've got the right attorney for your case? How do you vet an attorney if you haven't had to hire one before? And so that's the other thing that the 24/7 hotline can do for a member and for my client, is provide them with a peace of mind that, guess what? I don't have to worry about that. That's done. And if I end up in a bad situation, I know that Doug has got my back. I just call U.S. Law Shield. They'll get him to take care of it, and we're good to go. So I think that the 24/7 hotline is an amazing feature of the U.S. Law Shield program, and is something that really sets U.S. Law Shield apart from everybody else.
Can you talk to us about the importance of attending a gun law seminar?
When you carry a firearm, you will be held to a higher standard of care than everybody else, especially people that don't carry firearms. When you carry a gun for protection, and whether you carry it open or you carry it concealed, you need to understand the law. You have a duty, and maybe the law, maybe the statute that allows you to carry concealed doesn't tell you that you have a duty, but I'm here telling you that you do. Because when you carry a gun, a police officer or a prosecutor is going to hold you to the standard that you are proficient with using your firearm. And in Colorado, you can get a concealed handgun license without ever having to shoot the gun. So it's important, it's critical, and I'm challenging you and I'm charging you with this duty to seek out the seminars that U.S. Law Shield puts on. Go to your local gun range and get involved and shoot your firearm, because if you are not prepared, and being prepared is much more than just paying your U.S. Law Shield membership dues, but it's being prepared, being an armed and educated citizen. You have to be educated, because there are plenty of people that carry firearms, and there's what we end up hearing about in the news are the people that carry firearms are not educated. The ones that are not educated, the ones that decide to walk into a business with a firearm that they don't allow firearms. Someone that walks through a security area of a building with their firearm and says they didn't know the law. And that's the type of people, or that's the type of person that really hurts our cause. And it makes my job more difficult to do. It makes it more difficult for you as a gun owner, as the armed citizen, to feel accepted in the community, because not everybody likes the fact that we will arm ourselves and protect ourselves against threats that come towards us. So it's critical that you are not just armed, but you are educated.
Thank you for watching this webinar. I truly hope you learned some valuable information from Doug Richards. Now I would like to introduce you to U.S. Law Shield's President, Kirk Evans.
Thank you, Sherry, and thanks to all of you for watching and participating in this webinar today. And also thank you for being part of our cause to educate and empower lawful gun owners. Our mission at U.S. Law Shield is to provide a legal defense for any lawful gun owners that are forced to use their firearm in self-defense. No attorney's fees, no caps, no limits. We've got your back. I'd like to invite you to come be part of the nation's largest network of law-abiding gun owners, over 200,000 strong, plus the nation's largest network of firearms program attorneys. I'd like to personally extend to you our President's offer, and that includes two things. First, our Platinum Plus membership. The Platinum Plus membership locks in your rate of $10.95 a month for the lifetime of your membership. Second, if you pay for and purchase an annual plan today, you will receive 2 months free membership. For more information, please go to uslawshield.com/CO webinar and enter the promo code 2FREE to take advantage of this special offer. Thank you again, and we look forward to seeing you at webinars in the future.